You are watching Morning Musings with Reinhard von Hennigs, chairman and founder of Bridge House Law in Charlotte, North Carolina.
What is Apple Music? Hello, this is Reinhard von Hennigs. And you may ask yourself, or you may ask me next time you see me, why do you ask this question? Isn't it clear? It is this music thing on your phone. Well, there is a story to that. Apple has recently suffered a setback in the brand name dispute in the United States, which is ongoing for over 8 years. After Apple launched the music streaming service, it found itself in discussion with a musician. An appeals court in Washington state sided with a musician who took action against the registration of the trade name Apple Music. The trumpet player Charles Bertini claims that he has been using the Apple Jazz brand for live performances since 1985, and he sees a risk of confusion. There is a trumpeter versus the Apple. Apple's journey of using its own company brand on everything music-related has been difficult. Let's start with the Beatles. With the Beatles, you may think, yes, with the Beatles. The members of the legendary band set up in London a company called Apple Corps in 1968, and their purpose was to, you can guess it, make music. 10 years later, Apple Corps sued Apple Computer, a newly created company formed by Steve Jobs and Steve Wozniak, alleging a trademark infringement. The dispute was settled in the 1980s with an amicable agreement. Apple Computer makes no music, and Apple Corps makes no computers. So both of them were clear in the industry they are serving. Later in the years, however, Apple Computer bought the Apple Corps trademark. Apple Music is now a trademark registered for entertainment services, namely providing music, information in the field of music, and commentary and articles about music, all online and through mobile devices. The registration does not cover, and here we come, the use of Apple trademark in connection with live performances. And the trademark is not registered for live performances or for entertainment services featuring live music. And this is how the trademark dispute between Apple Inc. and the trumpeter Charles Bertini started. Bertini claims that he had been using the Apple Jazz performance brand since 1985, and he is very confused, or maybe the customers are very confused about the Apple Music trademark. As mentioned earlier, the Court of Appeals had sided with Bertini and rejected the registration of Apple Music for live performances. Well, remember, this dispute is specifically related to the use of Apple Music in connection with live performances, not for any kind of music recording. So the court found that there is a real difference between the use of Apple with the Beatles recording trademark and the Apple with regard to live performances. The United States Supreme Court may have a say on that later, we don't know. However, if Apple does not appeal the current judgment, it may need to consider changing its brand for its music streaming services or find a way to coexist with Bertini's use for Apple Jazz for live performances. So what are the lessons learned from this Apple versus Bertini case? Number one, if you are a company owner or a company trademark responsible, be mindful of existing trademarks. Before launching a new product line or service, or in this case, extending Apple Music to live performances, it's important to conduct a thorough trademark search to make sure that the proposed name or the logo or the trade dress or whatever it is not already in use or registered by someone else in the same or similar industry. This can help to avoid potential trademark issues later down the line. Number two, be aware of different categories for food, goods, services. Trademarks are registered for specific categories for goods and services. It's important to understand that the scope of the trademark registration is exactly that, and to ensure that the proposed use of your trademark does not infringe with any existing registration. Number three, Trademarks can be limited by geography or scope. The fact that Apple was able to secure the Apple trademark for music recordings does not mean that it has unlimited rights in the music industry. Bertini's use of Apple Jazz illustrates that it can be limited by scope. Also, trademark filings are only limited to the country where it's filed, so it's limited by geography. A UK trademark is not a German trademark, is not a United States trademark. Trademark disputes, and that's my fourth takeaway, can be complex and time-consuming. The case Apple versus Bertini has been in and on of the courts for nearly 8 years. Trademark disputes are complex and time-consuming. They require resources, and it is important to have a solid understanding of the trademark law before you're really ready to jump into a new trademark. Overall, what is the key takeaway? The Apple versus Bertini case highlights the importance of conducting a search, understanding the scope of existing trademark registrations, and organize your new company's idea accordingly. Let the music play.
Whether you're a private citizen, an international business leader, or simply someone eager to stay on top of the latest news, this book is a great way to get caught up on the most recent developments in the worlds of international business, tax, politics, and social affairs. Go to morningmusings.com and order your copy today.
Thank you for joining us today. If you would like more information about British House Law, please visit our website at bridgehouse.law. Before you go, make sure to like this video and subscribe to the channel for more up-to-date content. British House Law, business-minded, client-focused.